You believe your doctor was careless and caused you significant harm and injury. Now, the doctor, on the other hand, turns around and says, no, I was using my best medical judgment to treat you. Don't blame me because you suffered a complication. Who's right? Who's wrong? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now you believe that your doctor violated the basic standards of medical care, causing you significant harm and injury. And now in reply, the doctor turns around and says, don't blame me. I didn't do anything concerning malpractice. I treated you appropriately. There were a number of different options available, and I used my best medical judgment using my experience. The fact that you suffered a complication or a problem is a known recognized risk of the procedure. So don't hold me accountable, don't point fingers at me simply because you got a complication. Now, who's right and who's wrong? Well, you should know that in New York, in order to show that we have a valid basis for a case, we must get a qualified medical expert to confirm, number one, that the doctor did violate the basic standards of medical care, that wrongdoing had to have caused an injury, and the injury has to be significant or permanent. Now, in doctor's viewpoint, he says, hey, there were a number of options available. I talked to the patient about all these different options and alternatives. She selected this particular option, which in my opinion was the best option available. Simply because she got a complication or a problem as a result of that doesn't mean I did anything wrong. Now, you know what? That's a very compelling argument, and the doctors and their defense attorneys use that argument very often. However, here's where that argument doesn't hold water. If you remember the movie My Cousin Vinny. That's when the doctor's choice to use this particular option falls below the standard of care. If the doctor has multiple choices on how to treat you, and now supposedly he teaches you and educates you and gives you all the information that you need in order to make an educated decision about which option is the correct one for you, assuming that's the case. Now, if he chooses an option that is below the standard of care, that is inappropriate, now, in that instance, the doctor's defense is not going to hold up. If the doctor turns around and says, listen, all of these options are medically appropriate, and now simply because I chose one and the patient got injured doesn't mean I did anything wrong. That may be true, but if we can show that the option that he chose fell below the standard of care compared to the others which were within the standard of care, now we stand a much greater chance of having a jury give you a verdict in your favor. So why do I share this great information? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I understand you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.